Let's say you've gone to your estate planning lawyer and you have a good estate plan. A good estate plan includes not just a will, but your durable powers of attorney. Let's talk about your financial durable power of attorney. Under that document, you appointed somebody to make decisions for you, especially if you're not able to do so yourself. Oftentimes, the power of attorney document will take effect immediately. We recommend that actually here at ELG Estate Planning. Why? Because we work so much with long-term care issues, we know that it's very difficult to get a doctor to say that the person no longer has capacity. All right, that aside. So you have a financial power of attorney you've appointed. Can you fire them? Absolutely you can, as long as you still have legal capacity. If you want to fire them not because they're doing a bad job, but because you no longer have the cognitive ability to understand things, what do I mean by that? Perhaps you have Alzheimer's, perhaps you have some form of dementia, and prior to that taking over, you were in a good state of mind, but you knew that the Alzheimer's would render you incapable of protecting yourself, so you put a durable power of attorney in place. Now you're at the point where paranoia sets in. And if that's the case, I am probably speaking not to the person who drafted the power of attorney, or signed it rather, but the person who was appointed under that document. And paranoia is a very, very common effect for those who have dementia. The person who has the dementia might want to fire their POA, their attorney in fact. Can they do so? Not if they have lacked capacity, not if their capacity is gone now. In order to revoke a legal document, they still must have capacity and understanding what they're doing. Once they lose capacity, they can't revoke any documents. They can't prepare any documents. They no longer have legal capacity. The law will no longer allow them to do anything with regard to their legal affairs. That's why they've appointed somebody under a power of attorney. So once capacity is gone, no, a power of attorney document cannot be revoked. The POA cannot be fired. That might give some solace if you are acting as a POA and you know your dad is accusing you of stealing money. He's reporting you to Adult Protective Services. He's doing all of these things because he has paranoia. None of it is real, none of it is justified, and you might have to defend yourself. But you know what? Adult Protective Services and other agencies are very, very familiar with these claims of financial abuse when somebody has dementia, because they think everybody is stealing from them. On the other hand, maybe your question was, I have capacity and I no longer like who I appointed as my power of attorney. I don't want them to serve for me because they're getting themselves in trouble. They're disagreeing. I told them, for example, they can't act on my behalf, but they started acting on my behalf, and I have capacity. I want to fire them. Yes, if you have capacity, you can revoke your power of attorney. You can fire whoever you said would be acting on your behalf, and then you do a new power of attorney. And maybe you simply made a mistake. The person who you thought you can count on, you can't count on. Yes, go ahead, do a new durable power of attorney, and mind you, don't do an online form. Why? Because you already recognize you're in a situation where there's problems. Bring in the counsel of an estate planning lawyer and their expertise to make sure you have a good power of attorney, you appoint the right person, and successors after that.